All right. Today, we're getting into the part of the lateral conversation that most attorneys find either exhilarating or terrifying, depending on how honestly they've been thinking about it. We're talking about your book of business, not your reputation, not your billing hours, your actual book, the clients you have, the clients you originated, the clients who follow you, and the very different category of clients who you bill but don't actually own. I've had this conversation in some form with thousands of attorneys over 20 plus years. And I'll tell you what I've consistently found. Attorneys at every level, from senior associates trying to build a book to $10 million partners thinking about a move, are almost always working from an imprecise picture of their own practice. They have a sense of it, they don't have a disciplined analysis of it. And imprecision about your book of business is really expensive. It leads to overestimating portability and then disappointment when clients don't follow. It leads to underestimating portability and then leaving leverage on the table in the lateral negotiation. Both outcomes are really bad. So today, I want to walk you through how to actually think about this, how to organize your client base before you do anything else, and how to apply what I call the portability framework, an honest assessment of what will actually follow you if you move. I'm Andrew Wilcox, and this is a lateral brief. So, map your client base in detail and do it on paper, not in your head, on paper, in a spreadsheet with actual numbers. Here's what the map needs to include every client you've worked with in the last 3 years. For each client, the total billings over that period, the origination credit, specifically whether you originated that client or received them from another partner or from the firm's existing relationships. The nature of your personal relationship with the decision maker at that client. Do you have a direct relationship with general counsel, with the business owner, with the executive who controls outside counsel decisions? Or do you primarily interact with more junior contacts? Then, the stickiness factors. Have you been the lead attorney on all of their matters or just some? Have you built a team relationship with that client where your associates and colleagues are also embedded? Or is it a personal relationship that runs almost entirely through you? And then the friction factors. Is there a rate agreement between the client and the firm that would need to be renegotiated? Is there a enterprise relationship where the firm's total relationship with that client includes departments and practice areas that have nothing to do with you? Is the client on the firm's key client list with firm level resources dedicated to that relationship? When you fill that in honestly, you have the beginning of a real picture. So the next step is applying the portability framework. I think about portability on a spectrum, and I want to walk you through the four categories. Highly portable. This business where you originated the relationship. You are the primary or sole relationship holder. The client's primary contact is with you personally, and there are no structural ties, no enterprise agreements, no firm level commitments, no institutional entanglements that would complicate a transition. These clients will, in all likelihood, follow you. They will work with you, not with your letterhead. The next one is likely portable. This is business where the personal relationship is strong, but there are some institutional factors. Maybe you inherited the client, but you've deeply embedded yourself over years and you're genuinely their lawyer. Maybe there's a modest firm level relationship, but the work flows primarily through your hands. These clients will probably follow you, but you need to think through the conversation carefully. And there are factors outside your control. Moderately portable. This is where it gets complicated. Strong personal relationship, but rate agreements that need to be renegotiated. or the client values you, but also values the institutional brand. They came partly because of the firm and partly because of you. Or the matter is in flight and transition would be disruptive. These clients may follow you under the right circumstances with the right transition management, but they're not automatic. And then difficult to move. These are the institutional clients. Clients whose relationship with the firm predates you and would survive you. Clients where the work is distributed across multiple partners and practice groups. And your role is one of many touch points rather than the central relationship. These clients almost certainly don't follow you. You should not build your lateral narrative around them. So, step 3, do the math and do it honestly. Add up this realistic column, highly portable plus likely portable. This is your core portability number. Add the moderately portable column with a discount, maybe 50% risk adjustment to account for uncertainty. That gives you a range. Now, compare that range to what you've been telling yourself your book is worth. Are they the same number? If not, if your realistic portability range is meaningfully lower than your mental number, that is important information. And you're better off knowing it now before you walk into a lateral conversation than discovering it after. So, step 4, understand how lateral compensation actually works. Law firms making lateral partner offers price those offers based on their assessment of what you'll bring with you, not based on what you build today. They'll discount your number. They'll apply their own portability analysis and they'll structure compensation accordingly, often with some combination of guaranteed draw and performance components tied to what you actually transition. Going into that negotiation with a realistic, documented, well organized picture of your book puts you in a fundamentally different position than going in with a vague sense of your numbers. The attorneys who do this work up front get better deals. Full stop. So, one final thought. The goal of this exercise is not to shrink your sense of what you're worth. Sometimes attorneys do this analysis and find that their portable book is larger than they thought, that the personal relationships are stronger. The institutional dependencies are actually fewer. That's a great discovery to make. The goal is to replace an imprecise picture with a precise one. Precise pictures lead to better decisions, better timing, better targets, better negotiations, and better outcomes. Your book of business is the central asset of your career. Treat it like one. I'm Andrew Wilcox. This is a lateral brief. If you'd like to have a confidential discussion with me about your practice and your career goals, please email me at andrew@wilcox-legal.com. And as always, grateful, Andrew Wilcox.